All right, let's talk a little bit about revocable trusts. So first of all, what is a revocable trust and why would you ever want one? Revocable trusts are a fairly popular technique in the state of Florida. What they are is a document that you sign, setting up a trust with yourself as grantor, yourself as trustee, and yourself as beneficiary. What that means is you are the person contributing the money and property into the trust. You are the person managing the trust once it is signed and put into place. And you are the person for whom the money will be used on a going forward basis. You can set up a trust for yourself, or sometimes you can do a joint revocable trust for yourself and your spouse. So why would you ever do this and take the time to put money and property into it? Couple major reasons for doing it in the state of Florida. The first one is to avoid probate when you pass away. So as a brief overview, all assets that you own in your individual name will go through probate when you die in order to get to the right people. The exceptions to this rule are jointly owned assets, like a jointly owned bank account, and accounts that have a pay on death beneficiary. Those are not going to go through probate. Those are going to pay out to whoever that person is that's named. Everything else, like bank accounts, savings accounts, money market accounts, CDs, vehicles, real estate that is not homestead, because that is treated differently in the state of Florida, jewelry, artwork, things with value, all of that will have to pass through a probate. And if you have a significant amount of savings, then you will have to most likely do what's called a formal probate in Florida. Formal probate is for people who own more than $75,000 worth of probate type assets when they pass away. In formal probate, your family is required to hire an attorney to draft the necessary documents to submit to the court. If you have a will, the attorney will offer the will for probate. And assuming that it was done correctly, it will be accepted into probate. So that means that its terms will be followed, but there are a lot of other things that have to be done, such as notifying creditors that you've passed, publishing a notice in the newspaper, waiting 3 months for creditors to come forward with claims, paying the claims if valid. If not valid, then fighting it out with the creditor. Doing things like, in the meantime, getting property ready for sale, selling the property, all different things. You have to notify the Medicaid people that you've passed away, send them a notice of probate. Any other creditors that are known, we have to send notices to, and things like that. It can be a very long process, especially if there's someone who is challenging the will, or if there's no will, challenging who should inherit the property, or the fact that you may have given away property prior to death, saying that that was done under undue influence or something like that. If that's the case, then it can get very long and drawn out. I've seen probates that have lasted 10 years. Now, that's not typical. Typically, they're much shorter than that. But I would say a year is probably right around average. It's supposed to take less than that, but it usually doesn't. So in order to avoid that whole process, and avoid having to hire an attorney who, by the way, can take a percentage of your assets as their fee, in order to avoid that, you would want to set up a revocable trust, retitle your assets into the trust while you're still alive and healthy. And that way, when you do pass away, everything is owned by the trust, not by you. So there's nothing to probate because you don't really own anything. So all the assets will be distributed to the people who are named in the trust as people who should receive your property when you pass away. So it sort of functions as a will substitute that way. The trust will say who should receive your property upon death and in what percentages or proportions, who should be the successor trustee if you ever die or become incapacitated. So in a lot of ways, it's similar to a will. The difference is you have some homework to do, and that you have to transfer your assets like bank accounts and non-homestead real estate and savings accounts into the trust while you still can before you pass away. The other main reason for doing it in Florida anyway, for setting up a revocable trust, is to avoid a potential guardianship of the property. There's been a lot of bad press lately about guardianships in general. Guardianship disregarding all of that because that's a separate video. But guardianship in general is a court supervised process, and therefore it can be expensive, time consuming, and a little bit onerous. In guardianship, first of all, you have to hire an attorney to represent you if you're the guardian. Um, and the process begins with someone petitioning the court to get appointed as guardian of your person or property, which means they feel that you don't have the ability to care for your own property yourself or care for yourself as a person, and they are going to take guardianship of you, similar to a parent-child relationship. And in that relationship, the guardian will manage all of your property, and they have to submit reports to the court every year, such as accountings. They have to hire an attorney who will likely assist them with filing the reports. There are hearings that have to be attended, at least in the beginning, to get the person appointed as guardian, and so it can get rather expensive. And it involves the court, and so a lot of people would rather avoid that as well. And so once again, if you have a revocable trust that owns your property, so that you really don't technically own your property, then as you age, if you do get to the stage where you cannot manage your property anymore, it's okay. You don't have to go to the court and get a guardianship set up. No one would have to do that. What would happen is the successor trustee, who is named in your trust, will take over managing all of that property. So part of the process you'll go through with me is deciding who should be the successor trustee. And if it's your spouse, great. If you're married, if not, let's talk about, we'll talk about who your most responsible family members are, who might be suited for the role, or you can always name a bank or a financial management company to take on that role. So hopefully that gives you a little bit insight into what revocable trusts are and why you would want one.